applicants, my land friends, Edwin Fardier, Sebufu. We have a representative for the applicant, Haji Hamis Chiguru. Is around. Standing in white. I believe we have representatives from the applicant.
I see. Is it only one and others? There is Ham Enterprises.
And others.
So he is representing the three?
He is representing the three and himself.
Haji Hamis Chikondi.
Yes.
Representing
The two,
1, 2, and 3.
1, 2, and 3. The Executive Director, Madame Babazi, KMD.
Executive Director
Of the first respondent, which is informed. KMD. Mrs. They're representing both respondents. My Lord, we are here in response to an invitation to receive directions and also respond to those directions on how to. But we've been served with a form which is giving proposed timelines for filing pleadings. I don't know if we can respond to this directly. Okay.
Lord, if I may, educate for the respondents. My Lord, it's our position that this application has been overtaken by events and is superfluous. United on 12th of November 2021. When the parties adopted the written submissions that had been earlier filed, and they also highlighted the arguments. My Lord, on that day, the court retired to make its judgment.
What was the forum?
My Lord, the quorum at the time was Justice Owen Ndolo, the Chief Justice, Justice Monda, Justice Raisi, Justice Chibita, and the late Justice Opiaway. My Lord, on the 5th of May, 2023, yes, my Lord. On the 5th of May, 2023, we again appeared before this court, my Lord, for reconstitution of the panel, following the unfortunate death of late Justice Opiaway. My Lord, during that appearance, the parties again adopted written submissions and the highlights that were made on 12th, 2021 before the new panel. And in the new panel, my Lord, Justice Luswata replaced the late Justice Opiaway. My Lord, during the proceedings, as the record will show, counsel for the applicants, after the adoption of the written submissions, was asked by the court, do you have anything to add? And the response unequivocally was, and I quote, my Lord, That is the position. For the appellants, we have nothing else to add.
So they say that was the position.
Yes, my lord. And that they had nothing further to add. My lord, the application that they seek to schedule today is an application that was filed after the submissions had been made by the respondent. So both the appellant and respondent had made their submissions. That's when this application was filed.
They had been filed.
They had been filed. And my lord, the respondents had an opportunity to respond to the submissions of the respondents. So they had the right of reply, which they exercised. So in effect, my lord, this application for judgment and admission is an application for judgment as we await judgment. So it is really superfluous and is only intended to waste the time of this court, as for all intents and purposes we are waiting for the exact same thing they seek to apply for judgment. If there are any admissions that we believe were made in the submissions of the parties, and we have responded to them as such. This application should be struck off or forwarded to the panel to deal with as the right to judgment in this matter. And it's our opinion that it therefore abates given the circumstances we have raised. In the alternative, where the court is of a different view, we are available to take the directions of this court in this application.
In response, my lord, the submissions by my learned friends are in the wrong place, because this is an administrative hearing for purposes of case management of the application which we have come to fix. And in any case, my lord, this application is to be heard before the panel, is the one seized with jurisdiction to entertain objections or things like that, which we think the respondent is entitled to make, and we can ably respond in the proper forum. Having said that, my lord, I just want to give a small background that the application was filed, yes, after the last session, applied for admission.
You're saying that when you appeared before the panel, which includes this is appeal,
Yes.
you did not file.
No, there were submissions. The court directed parties when we appeared, because the respondent was raising certain new grounds. And if you look at the record, you will see that there was a tug of war in the court on whether.
Because you're saying this is administrative, not even.
Yes.
Yes. I'm not part of the panel.
Yes, my lord.
Yes.
I'm just giving court some context.
When you received the
So when we received the submissions is when we realized that they had admitted the appeal. And
Okay, what I want to know is when you appeared, were the submissions on record?
there were some submissions, but they had also requested to submit on some additional issues of grounds, which we are also allowed to respond to. So in that process,
That was after court, after you appeared?
during the hearing,
Yes.
they made a request, as the record will show, to submit on foreign lending. That Okay, and so there were arguments there, and we also made our submissions in response. But having,
My Lord, if I may assist my colleague on recollection, on the 12th of May, all the written submissions have been filed, including the issue of
12th of May
12th, of November 2021. All the submissions had been filed, and we were just there to adopt them and highlight areas. And this included that ground which we were given leave to address, the ground of illegality. So we had been given leave prior to and given a schedule for submissions, which we met. So there was nothing new that came up on the 12th of November 2021.
anyway, my lord, let's not bog you down. The point anyway is that a party can apply for judgment on admission anytime before judgment. We don't have a judgment in this matter. But those are arguments we can make subsequently. However, when we received the notice for the hearing of the appeal, reconstitution of the panel, we did write to court. We wrote to the court on the 2nd of May 2023, and we observed that we have been called for the reconstitution, but we have a pending application for judgment. And the court
application came in after the first hearing.
Immediately after. When we perused the submissions, we filed the application. Because under Order 13, Rule 6, a party can apply for judgment on admission at any time before judgment. So that's why we filed the application. And we brought it to the attention of the court at the reconstitution of the panel. We wrote a letter and requested our pending application for judgment to be fixed. And the court wrote back to us and said that at the reconstitution of the panel, the court will only deal with the issue of reconstitution of the panel. It will not hear the application. And the court advised, the letter is dated 2nd May from the registrar of the court. The civil appeal. Yes. The reconstitution session. That is from the registrar, because we followed up. In other words, I'm trying to show you that the applicants are interested in this hearing of this application, and we've been following up for the last 1.5 years, trying to remind, and then the court was saying it was not ready. So, as far as we are concerned, my lord, we can receive directions on how to deal with this application. Whether it has merit or not is something that will be considered, and we can respond to it. I think that is what has brought us here.
The correspondence, I'm surprised that yes, my lord, just to respond that we were never served with this copy of the letter from the registrar. Yes, my lord. It was never, which is odd.
But it is.
It was not copied to us, not served to us. So I can't comment on comments of the letter that we did not receive. Clearly, whatever was communicated was only intended for the appellant, which is surprising because we are two parties in the ring.
Right.
My lord, in terms of what transpired on 5th of May, when we last appeared here, 2023, on reconstitution, the parties were clearly asked, is there anything to add? And the record will show. The respondent said there was nothing, so did the So we should all be satisfied the judgment is being written. If there are any admissions that were made in the submissions, we have a full Supreme Court bench. I don't think we can, the admissions will go unseen. So we pray, we reiterate our prayers.
Delivered, nothing is new to stop the delivery. No. You want to say something? Just
Yes.
wait. At the head of panel says that when they came up with the first hearing, where I just disappeared where it was. Okay, you said you had not filed the application.
Yes.
Yeah, but okay, later on, at the reconstitution, they asked, actually, just like Council Kampira said, the court asked whether you had anything to say. You said you did not have anything to say. I'm told the record states that, and that you are just waiting for the judgment. And in any case, if you have those issues which you think should be considered as admission, weren't they part of the written submissions? Wait, let me finish. I'm sure they were part of the submissions, and I'm sure you responded to them. Unless you're saying that you did not respond to them in your written submissions. But when you were asked whether you had anything to add, you said you did not have anything. That is on the reconstitution date. You did not have anything to add, and you were just waiting for the judgment. And the panel went ahead and prepared the judgment based on whatever they had. I'm sure the points you are raising here were all points that were raised in their submissions, and you think they should admit to them. Yeah? But you think that maybe it should be in another procedure. But I'm sure they are considering them in their judgment. I don't know what their judgment is because I'm not part of the panel, but the head of the panel says the judgment is ready. It's to be delivered on Tuesday. And whatever you are bringing in now is actually new. You didn't mention it at the reconstitution stage when they asked you whether you had anything to add. And I don't know whether you think it will add much what the panel would consider in their judgment. And okay, before I say my decision, maybe you can.
My Lord, I have heard you clearly, and I need to say this. Why would the court call us for pre-hearing to determine filing and format? I mean, wouldn't even be listed if the court has taken the position that this matter is already just waiting for judgment. The reason the court put us on the list as number one for pre-hearing is because the court recognizes that for 1 year and a half it has been sitting with an application of a litigant which has not been fixed. For 1 year and a half. Now we're talking of 5 days to Tuesday. But for 1 year and a half, this court had our application, didn't fix it, and we are entitled to be heard. Whether we have merit or not, we are entitled to appear before the panel. We are now hearing the panel's views, not from the panel, but from a member of the court. And we think we are entitled to be heard by the panel, whether we make sense or not. This is our right. So, my view is that having been guided for the proceedings of the 5th May that don't talk about anything else, is only reconstitution. We came to the court as diligent litigants. We wanted to raise this issue of the application because after all, the practice of the court is applications will be heard and disposed of first if they can actually resolve the whole matter, because the courts are breaking down because of so many judgments and cases. So for us, all we are saying, let us appear before the panel. Let us appear before the panel. It's our right as applicants, as appellants. Let's appear before the panel. The issues of whether or not the matters raised in our application are going to be considered in the judgment, these issues were considered. The reason why we filed the application separately is because our submissions, and right now I cannot recall, but the reason was they were not canvassed. This issue of the judgment was not canvassed. And it's our duty as officers of this court, as parties, in proceedings in court to bring to the attention of the court quickly that there is something admitted, so that judicial time is not wasted to write judgments and so on if something is admitted. So therefore, my Lord, our prayer is, let the court follow its procedure, which is come for pre-hearing, fix our application, and then a decision can be made. So that's our position.
You said you wanted to save judicial time.
Yes.
Help them to see where the people have admitted, but they look at everything.
My Lord, we protest. We protest the manner in which the court has handled us, because we have filed an application in this court for 1.5 years. We have not been heard, and now we've been told.
Mr. Wema, just listen. You say
yes.
Sit down. Can you sit down?
Okay.
You say you wanted to save judicial time, to save the judicial time, so that you point out what has been admitted and what has not been admitted. Unless you're saying that they brought out new points in their written submissions, which you're saying they should not consider. But otherwise, if you just wanted to save on judicial time, that is really, you've not done that, because they've already spent the judicial time. Their judgment is ready, please. So, and I'm sure they've considered everything.
My Lord, they have not. That's why we filed the application.
They have not.
They have picked. That's why we filed the application. When we were doing the submissions, my Lord, we were strictly dealing with the grounds. This issue of admission comes later when they file their submissions. And then at that point, we realize that actually there is an admission and we need to save court's time. So the proceedings of fifth, my Lord, the proceedings of fifth that my colleague is talking about, that we said we have nothing more to say, having been guided that the court will only deal with reconstitution, we were not expected to raise issues of the application. Besides, it was filed in the court.
It was filed. Whether you had anything else to say. You said you did not. You did not raise the issue of the application.
No. The application was in court, my Lord. I don't validate an application because I've spoken about it. I validate it when I filed it. And you had called me for reconstitution. And you called me today for a pre-hearing. If there was a judgment, I didn't need to be called here. I could just receive a judgment.
That's what I'm saying. Maybe I wasted your time calling you because I had...
No, my Lord, we protest.
I had not talked to the head of the panel.
We need to see the head of panel. We protest this.
You can protest.
This is not fair.
This can be referred to...
Yes, let's go and see the head of the panel. We can't allow this.
Because it's Tuesday.
No, we shall go and see him. We shall look for him.
Where are you looking?
My Lord, this will not end here. We are not going to accept that a party can be muzzled for 1.5 years. We are not heard, and then we are told all of a sudden there's a judgment. No, this will not happen. We object in the strongest terms. This is muzzling. We shall not accept this. Hear us and dismiss the application if it has no meaning.
What are you
Why is the court afraid of our application and the parties? We are saying the court will be interested in what we are saying. We are saying a party has admitted this is a routine application. What is going on here? I have one client. In this court.
them. I don't know them. I don't know them. I'm just a lawyer. I don't control them. I'm just a lawyer. I don't know them. I don't know them. They are not my clients. I don't know them. I cannot take responsibility for them. I don't know them. In here, yes, I don't know. I don't carry them. I don't know them. That is true, my lord. I don't know them. I don't know them. Me, I just came to court. I don't see them, my client. My lord, I'm in a tricky situation. Me, I'm just arguing a case. Where is my client? My client is not even in court now. No, I cannot take responsibility for them. I don't know them. Okay, let's tell them to get out. I thought this is okay. I'm not in control. You are doing a disservice. My lord, I want to go on record. My lord, I want to go on record. I have one client or 3 clients who came. No, I don't know. If the court, the case is a public interest case. Everybody knows about it. So, I don't know. That's not part of, I don't see him. That's not my brief. My brief is to argue law here, which I'm arguing. Yes. No, I don't know. No. I don't take responsibility for anything that happens at court. My lord. My lord, I found them with my colleagues. Yeah, I came in late. It's my colleague who knows about this.
My lord, my senior colleague should act senior. His client came here and not be as part of the him, but he has influence in his client. His client came here with hooligans and the press. And they think they will intimidate counsel, they think they will intimidate the court. And they're very
But where's your client?
I don't know. I don't know where it is, and I can't leave now. I'm here at the bar. I can't leave. I'm here. I'm an officer of this court. I'm here.
Does he want me to believe that he's also a hooligan? I mean, if he's heading all those hundreds of hooligans here?
My lord, I don't know if Diamond Trust Bank deals with hooligans, but by the time they do a transaction for $10 million,
Because they are talking I heard them talking about Kamkire, what?
I don't know.
I don't know. So,
I don't. For us, we're just lawyers.
not in good paper, so
I was
they
not
must
there.
speak for the other party.
When Diamond Trust did a deal with him, I didn't know anything. The case came later to me, many years later. So you can see the situation I'm in.
Yeah. But I advise him, that's not the way to handle court matters. Okay? By bringing hooligans to shout in court, that will not influence. Me, I'm not part of the panel. I came here for an administrative matter. Okay? And your matter was, they brought files which were supposed to be dealt with administratively. But then,
My client is here.
maybe your client should also get out.
My lord, my client is here. Maybe he can.
No.
You are asking for him, is he?
Yeah.
No, point of information. I'm also a friend and I know that I have a right to be admitted.
You have a right to be heard, but you are talking through your
And
client.
I'm here.
Please.
So that the hooligans
I
can brought them.
brought the old guys. Why did they fight the case?
Okay, you can only be, unless you are saying that you no longer want your lawyer to represent you. Please. Yes, have you finished what you're saying?
But my lord, I think
proceedings were recorded, I said all I had to say. I showed that I was unhappy, which is normally part of proceedings. And the court is going to make its position clear. And then once we receive the formal position of the court in those proceedings, then we see what happens. We shall follow the available channels.
Yeah.
Yes. So that's it.
I hope you're not taking those hooligans to the head of panel.
My Lord, let the record show that I have a client, not hooligans. I just have that is
Come with
it.
hooligans.
No, I found them here, my colleagues.
My Lord, the conduct of the applicant should be recorded by the court. Otherwise, this is going to become a way of practice, which we are not trained, my Lord, as advocates to move with hooligans. But if that is necessary, I think all of us will come with our own hooligans to shout and fight, but that's not the way, my Lord. So I think the court needs to stamp its authority over and take authority over the court proceedings. They cannot be disrupted by intimidation. Otherwise, why would we come to the court to adjudicate a matter? We'd sort it out on the streets. That's where hooligans are supposed to sort out issues.
Had been put on today's agenda. You are invited, both of you, to come here. We thought this matter would be had sometime, probably in July. So we're supposed to schedule, like when you are putting in submissions, when the matter will be had. But then, as I told you already, I was informed by the head of panel. What I've told you before, and what Mr. Kamkira said, actually, that's what he told me, that's what is on record. The times you came here, you were asked whether you had anything to say. You say no. No, you've already said. The record is there.
Yeah, but you can review your decision. Maybe you hear some more. Let me emphasize. Then we don't, just because we came on 5th May, and that therefore I have allowed my application for bed. No. So I am saying, if the reason is 5th May, no. 5th May we came for the Constitution. And that's why you have called us for a pre-hearing of our application, because you know it exists, my Lord. So all we are asking for, treat us fairly and equally, like other litigants. We may have a weak case, a strong case, but we are asking for our day in court to see whether the application has merit or not. But it's being determined in a very summary manner. Your applications are dismissed when they are called, parties make arguments, then the court makes a decision. Now a precedent is being set that an application will be determined at filing, and then you say that's not a proper application. This is all we're asking for.
Okay. And I've given you the information. I've given you the information by the head of panel. I'm not part of that panel. Head of panel has given me the information that has affected this matter. The information that I've relayed to you. And on basis of the information I've got from the head of panel, I cannot schedule this matter. But I'm a single judge. You can apply for a reference to 3 judges. Okay, but the judgment, the head of panel tells me that the judgment is on Tuesday.
No problem. Yes. No problem. And before Tuesday, we shall see what applications to file. Yes, because we are saying this is a travesty of justice, and it's not good that the highest court in the land should treat a litigant like this. So we are saying we shall make the formal applications and say what is wrong with this application.
Do you really think that the matters you're raising here will not have been covered?
Yes.
Because
yes.
You're saying that when you saw the written submissions, you found out that these people are admitting
yes.
some issues.
Yes.
So everything is in the written submissions.
But we did make submissions on the admission specifically in our submissions.
You think these people people are stupid because they can see that they've admitted.
No, but why don't you allow me to argue my case? Why should I leave it to the court to find out my case for me?
No.
I am saying, give me a
Because
chance.
you came to the court
No, but-
knowing that
but
they
my
will
lord-
look at the written
My lord, what
submission.
is so special with this application? What is so special?
You said
We are just-
admission. They
Yes.
should admit
Yes.
some points.
Yes.
Yeah.
They admit the appeal. We should not even have anything
You
else.
are
apart
saying
from-
you wanted to save judicial time, which you've not managed to do. Because
No.
the judgment is ready. Please, I'm stopping there. I'm not
Okay.
adding anything.
Most obliged.
Yes. So I think my decision is clear that on the basis of the information given to me by the head of panel, which I think I've clearly laid down, but also which I think was put forth.
My colleague that on the 5th, this is the problem. On the 5th we came for reconstitution. So when they asked us anything else you have to say, it was about the reconstitution. And we're okay with the panel. To expect that on the 5th we would have spoken things outside the constitution. This is what is causing the problem.
Mr. Mwema,
I know you keep referring to
Ms. Mwema, that's the information I got from the head of panel, that because you did not raise it, you cannot raise it now.
No.
Okay, okay. Mhm.
You told me for reconstitution.
That's it. You can see the head of panel. This was just an administrative.
Yes, but you have made an injurious decision to an application pending before this court. It's not just administrative.
But even if I was to say that I give you dates, no, I've not. Even if I give you dates, that you cannot put in submissions prior to. No, but
I can put it.
and they respond and they rejoin
Respond since they don't like the
before Tuesday.
Me, I can put in submission.
Before Tuesday.
This court works in presidential petitions on Sunday. I will submit. Give me a chance, I'll submit.
You can submit, but the other party also has to be given
Yes. Then
time.
You enlarge the time. What is so special with Tuesday? Then you hear us on.
I'm not the one to fix judgment dates.
My lord, through your good office.
The judgment is already fixed.
I know that this court can fix a judgment on Tuesday. See the head of this court or the head of
You
panel.
don't have to request me.
No,
It's
let
your
it
right.
be. Let it be noted,
It's
because
your
this
right
is not
to see the
something.
head of panel.
Yes,
It's your right.
we object to the reference to 5th of May. My colleague said we said nothing. We were supposed to object or allow the panel, and we had nothing to say.
My lord, we were
And
not
that's the
asked.
information I got from the head of panel.
My lord, we were not
Exactly
asked.
what he said. Yeah.
My lord, we were not asked to accept or reject the panel. What we were asked was regarding adoption of our submissions and the highlights
Whether
of
you
our
had
bid and the
anything
close.
to add or what?
Anything to add.
But
So
we
if
wrote
there was-
to the
if there was-
court.
If my lord, there was
We had
an issue
written.
with regards to admissions or pending
We had
application
written
which
to
would
court.
stop judgment,
My
it
lord, we
ought
wrote
to
to
have been
court.
raised. It was not.
We wrote to
My lord,
court.
this is just to waste time.
No,
And
they are the ones
unfortunately,
wasting our time
we are
for
busy
one year and a
as
half.
indulging.
Please, let him talk. He
My
let you
Why
talk.
is he saying I'm wasting time?
My lord, we're
Yeah,
just
let him
indulging
talk.
the applicant in a time-wasting venture.
He's the one wasting time.
So I'll pray, my lord, we take your decision, and those who want to go and appeal or shout at the head of the panel, they can go on the next step.
So, this matter is okay.
Civil reference number 5 of 2023, Subiru Pareya and Mera Investment Limited, Ambulance, versus Bank of Uganda, responding. Justice of the Supreme Court.
Bannayuganda bannange ekisookera ddala omusango guno muzze mugugobera okuviira ddala mu ntandikwa nga guli mu High Court ne gujja mu Court of Appeal kati guli ku Supreme Court neera kyannaku era mpulira ennyiike ku mutima tibannaffe abamu batera okukolesa political influence and authority out of mere impunity and arrogance okugezaako okukakkanya bannayuganda bannaabwe naye sinaki n'okukakkanya sisitimu yaffe n'eggwanga lina okutwaliza ewamu ffe twenyumiriza mu President Museveni kuba yalwana okukomyawo obwenkanya mu nsi era eddembe mu ggwanga mweriri kyova olaba bannayuganda nganzi tusobodde okuvaayo ne tukola bye tukoze ku mulembe guno ne abantu abamu bazze ne beerimbika mu kifaananyi ekirumira eggwanga ate nga bali kakkanya bukakkanya. Omusango guno briefly nakola audits ku akawunti zange nensanga nga bajjako billion 120 nempandiikira banka nembagamba nti bannange ndaba wano akawunti zange tezigatta bulungi ne sente zino zaavaako mujje tutwe tukole reconciliation out of mere impunity tebanziramu nembagamba ngenda kulopa nendoopa omusango on top of which baali bakola ne some transactions ezimu nga tebalina license nakyo nenkizuula nentwala omusango mu court ku county ezi biri unillegality contrary to section 117 of the Financial Institutions Act that requires for anyone to do financial institution business in Uganda, they must have a license from Bank of Uganda, which is the regulator. Abantu bano ne bayita ku High Court ne bababuuza nti bannaye mwalina license nti license tetwagina nti lwaki kiruwa kyono kibiseera eyo yali ng'ali mu keke naga out of impunity and arrogance twati tugyetaaga. Omulamuzi Adonyo nayisa judgment ku High Court nti illegality yino nogikiriza bagikola ki tebakomye kumenya tteeka nene olikiriza bakoze ki n'akola judgment. Abasenga kye mutaategeera out of impunity bano abaana ba Edwin mbayita baana kuba embeera gye beeyisaamu tebamanyi nti eggwanga abantu naffe tujja kufa tukole ki tuveewo naye kati Uganda yakusigalawo oba weetuli oba tetukola ki kuliko n'abaatusookako naffe kwe tuli saawe naffe tujja kukola ki tujjagenda naye out of mere impunity. Omulamuzi Adonyo mwena kye mutaamanya weyamala okukola judgment eyo bamusindika bamudemotinga ne bamutwala Soroti balina obuyinza n'amaanyi ki mangi ate nga nkiwa kyannaku ebintu nga bino n'omukulembeze alabe katabikola ki tabimanyi nti obuyinza babukolesa ne bayita ne balikoze eki bwe balikomye ne ku bantu ba individual ate abavudde ne tuwa na Uganda mmekwata nze hamu kukolesa dembe n'okulaba nga tusobola okukola ne tukulaakulana ne bakola appeal mu court of appeal bakola appeal mu court of appeal abalamuzi tebaali clear ensonga eno ya illegality the substantial issue of illegality upon which judgment was passed was completely ignored ne baagala okugamba nti omusango gudde kuki ku High Court naye ne tukola appeal ku Supreme Court. Watutuka mu Supreme Court outside the procedure Edwin oyo n'asaba ddolo. Actually, I'm very dissatisfied with the Dolo nga Chief Justice because he doesn't have the backbone. Namusaba the additional submissions, which was irregular, because to make additional submissions under normal procedure, you seek leave of court. Nene bamukiriza for whatever reason. We are called submissions na gamba. What the substantial issue of illegality was never addressed by justices at Court of Appeal. What the song to yatuni waomba lamuzi bana Court of Appeal naye ate omuntu bana gusala ngayo guyino okusalibwa mu direction ya Ham gujja kusaba naffe bana abagwira abajja okukolera wano kuba abantu bano nola batafuna license tebagala kuwa misolo kugaba kola ndesende zonoze bakola bazitwala twewunya obwavu buvawa because these are exploitative banking structures ate nga tutekukuva ntuzikola ki ituzirwani sala kwa bakyayina ebijinji nga wolaba bini ebyakalugiro no Edwin kugaba baterawo ebijinji ne bekanga bakoze kinga batunyigiriza Edwin yakola submissions ezo n'agamba nti oba naagusala nga guyina okusalibwa wadde illegality yali addressed Court of Appeal definitely ina kuteekamu application of judgment on admission kwa the illegality from my court what it just stands echi farm kati bino ndaye mulaba na mu kirungi mbadde mu court mulaba batanya ogezaako okukakanya omusango naye Uganda sawe ni abantu milioni aga 5 banna abatembeyi bajjudde ruzira lwakuba bakola nga tebalina license fe utasasula trading license edduka balikola ki balisiba kati etteeka lino welikola ku munna Uganda so likola ku mugwira nze ndaba tekyawuka n'abantu basookawo abazungu bajjanga ne bawa ebijiiko n'ebikopo ne bawaayo bannyinaabwe ne baganda baabwe beba Edwin Kalugire bakyusiza bukyusa ki lwakuba bano bali mu 2023 ne bali mu colonial times. So kyannaku naye wekiri wekikola ki wekiri ne bannayuganda bannange mbakubira kino kirina president mulungi nnyo era awuliriza era wanaaba yeetegereza ebintu bino, I know you will intervene at a certain point in time. Kuba sikiwa president y'omuntu atayagala impunity, y'omuntu omukkakkamu nnyo, y'omuntu awuliriza buli omu. Ne bano abawansi bano simanyi waaki bakolesa obuyinza okusinga ne president ate kuba butoola. So kyannaku nnyo newe kiri bwe kiri saawa eno tuzze mu kooti nga batuyise for pre-hearing ne kyannaku nnyo tugatya fe tuzze bategeeza nti omusango gwasalibwa dde era ku Tuesday tugenda kujjako nsingo. Nsaasidde omukyalo omulamuzi gwe baasindise naye nga ddolo yamusindise akole dollar cent they are ready to do his bid dirty work. Kuba omukyalo omulabye naananaagira naye ne bimusukako nasoose nenyiga mu kusooka ne bambi ngenza okutunda bwete neetegereza omukazi nga mutume naye ate naye munnayuganda munaye kati nyiga lwaki ate oli mukamaawe naye nga kyannaku kuba bwe kitwe kikola ki bwe kiri wetuna tukyusiza mu mbeera mwe tulaba bintu nakwagala nnyo nsi yaffe mu butuufu Uganda kijja kubeera kizibu nnyo okulaakulana ng'eggwanga. So kiri eri ffenna bannayuganda okulaba nga tulongoosa mu sisitimu zaffe kyokka kuba ekibadde kwamu leero kyekiri ne ku balala bonna. Edwin Coates yazitwala oba twagala okkirizibwa tukola ki tetwagala okubeera mu mbeera nga bannayuganda ng'oli okutwala obutwazi mu faamu ya Kalugire omusango guba guwedde. Kati then what is the essence of courts of law? Courts waki tebazigala ne baddeeka abalamuzi. Omuntu waba yakola application ku file tosobola kudetermining appeal without hearing an application. Kitegeera kuba an application article telling that every person has a right to be heard. Kitegeera kati balina otuwuliriza kati bagamba nti nedda hamwe ekintu kyoleza kizitowa nnyo tujja kiwulira wadde bano bamenya amateeka ne illegality tetusobola bakwatako goli mundayo. In fact balinga batugamba abantu bano balinga abatugamba nti yes etteeka twalimenya ne temuyinda kimuli muli nfuzi temuyinda kyemusobola kukola eggwanga liyinza okuba nga lyammwe neti temuyinda buyinza mmwe baani mu bannayuganda mwogerangaani uwayo naye ate ekyennaku kyate bakolesa bannayuganda kugata okunyigiriza naye kyova olaba tujja mu kooti ng'eno kati omusangulu wakati wa Ham ne DTB banka y'abayindi ne bukyanga omusango n'ogugenda mu maaso mwani mulabyeko abayindi nga bajja musango tubeera bannayuganda nga mutulaba oli ali eri nange ndi eno ne tweyuza ne twetta ne twemalawo naye nga bali banyunyuta bagoba gonna bakola gonna bagafulumya. So eno ensonga si ya Ham, eno ensonga it's Ugandans versus colonial imperialists, as simple as that. Kati kiri eri mu bannayuganda ezi kyensiza eggwanga nti nsobodde okutambuza omusango n'okuva kwa High Court, Court of Appeal ne Supreme Court ate ne guvaayo n'ogenda mu court records byonna we biringa bikola nga wembisengese. Kati kiri eri mmwe kibasobola n'okunjija mu bulamu bw'ensi era mwonna mukiraba kati abantu basinga bafa nga tibugidde ne bano abantu mubulaba amaanyi ge bakolesa basobola n'okunzita naye abantu bange bonna bannayuganda benkolesa nze nkolesa abantu abasoba mutwalo gumu n'ekitundu. I have close to 1 million people dependent on me. Kintu kyonna kyonna ekimbaako don't stand back kubanze nyinza okuba nga siriiwo nga they've successfully terminated me nga banzise era kisoboka naye kyonna kyonna ekimbaako Kalugire nekiri wakiwano kuba katwano olutalo olutuuse banjagaliza kukola ki kufa ate nga nnwanira ki gwanga na gwanga lyaffe. Kati ekyo muyinza kirinda saa yonna naye nze ng'omusajja omusiraamu Allah yagira naba banzise era tebyewaananga nti banzi kitegeeza entuuko yange ebeera ekoze eba etuuse naye tetugenda